Yeah, before we officially start, I could take this opportunity to say the acoustics are not fabulous in this room. Ah, well, there we are, you see. They're not, and it is a real problem for the committee. And this is the only room in which we can meet. So I just make the plea to anyone who's passing who may have any influence on the matter, whoever that is, that it could do with improvement. The alternative, of course, would be to reduce the size of the select committee, but I'm not sure that would find favour with colleagues. Yes, round the room. Anyway, we should move to the formal business. At which point I say order. On behalf of the committee, Sir David, can I welcome you to our meeting this morning, and thank you very much for agreeing to come and give evidence. Can I begin by asking you this question? If the government when the government puts its withdrawal agreement and the future partnership to a vote in the House, assuming that there is one, and if it were to be defeated, say in December, could the government come back in March procedurally and have another go?
That is a hypothetical question. And you will know there is a general rule against being asked to decide again on the same question in the same session. But that rule is not designed to obstruct the will of the House. And so if it plainly was the will of the House, there are ways in which that could happen, yes. Partly because the nature of the motion, the words might be the same, but the underlying reality would self-evidently be different, not least because there might have been a change in either the negotiated withdrawal agreement or in the framework for the future relationship. So although if it was a different document, obviously there would be a different motion. I don't know, I wouldn't want to speculate whether if it was exactly the same document that they came back 3 months later for another bite, then I don't think the procedures of the House are designed to obstruct the necessary business of government in that way, in such a crucial thing. I hope that's
So would
helpful.
it require a business of the House motion to sort that out?
I hope not. I think it could be done by notwithstanding the practice of the House against reconsideration of a motion in the same session. But it would have to be that wouldn't be necessary unless I say not only was the motion the same, but the underlying political reality was the same, that nothing had changed in the intervening months in what was being put to the House in substance.
Right. The thing that would have changed is we'd be about to leave with no agreement in those circumstances, but I'm not expecting you to comment on that. But that would be a change in political circumstances. But it's helpful to know that it would not be an absolute bar.
I think it's unlikely, and I don't want to speculate on various things the Chair might do, but the Chair is there to facilitate the business of the House, not to operate a sort of series of strange theological, no disrespect to theology, but theological rules. They're there for a purpose, and it's the purpose that has to be looked at.
Well, that would be a great comfort to all members to know that. Emma Reynolds.
Good morning, Sir David. The government's memorandum to the Procedure Committee suggests that instead of amendments to the government motion on withdrawal being put first, that the motion itself would be put first and amendments would come afterwards. Could you explain, under that procedure, what would happen to amendments to the motion if the motion were to go through?
Well, again, that has to depend on what arrangements the government proposes to the House in the business of the House motion that would necessarily precede the introduction of that procedure. So as I understand it, they'd be quite unlikely to simply bring forward a exact copy of the procedures as happen on an opposition day, which is where this idea apparently comes from. In other words, that you put the proposed word standing part of the question. So that's what it says in their memorandum. They've looked at the standing order on that and think that's a template, I think was their phrase. Well, I take it a template is not like a technical drawing template. It's not to be copied word for word. It's an indication of what you might do. But straightforwardly and normally, if a motion is passed, then amendments to it fall. But as I say, there's no reason why they can't devise a procedure to get around that, or any number of procedures which the House would have to agree to.
If that's what they were wanting to do. But
if that's what they wanted to do, yes.
Okay, thank you. A number, as I understand it, 2 MPs have made suggestions to the Procedure Committee that there should be votes on freestanding resolutions. Instead of having a vote on the motion and then a vote on different amendments or the other way around, that these votes would be on freestanding resolutions. I think this procedure has been used before. Maybe you could explain. How could this work in practice?
Yes, without over-personalising it, let's call it the Grieve-Letwin thesis. Yes. As I understand it, the idea is that you would have a general debate on on the whole subject, and then at the end you would vote on a series of freestanding resolutions. It's a matter for discussion as to how many and how you might control how many and who might control how many. It's a matter of question as to whether they themselves would be open to amendment, or whether that would just cause such confusion not only to you, but perhaps more importantly, if I may say, to the public, who, because this isn't some sort of private practice, this is a very, very public and big moment. So you would go through the resolutions, and as I understand it, at the end of it, you would have a vote on what I'd call the principal motion, the 13-1 motion.
The government's motion?
The government's motion, yes.
Okay. Because it's been suggested to me that the innovation of having freestanding motions would be that, for example, if we were to vote on a freestanding motion that is not the government's motion, it's an amendment brought by...
not an amendment, a motion.
Sorry, a motion. It's a motion brought by a backbencher, for example,
yes,
on either side. And that motion were to have a greater majority than the majority on the government's motion, that somehow that would mean the government would have to take that motion rather than its own motion. But surely, if the government's motion has a majority, they would decide to take that forward.
Yes, the size of majorities has no procedural significance. I mean, you plural, are better able than I am to judge its political significance. But if, let us say, there was a resolution which expressed concerns at the lengthy continuation of a backstop procedure, and obviously I don't want to get into politics, but let's be realistic, where there might be a large majority expressing some concern at what that might mean, that might have a huge majority. But that's indicative of the House's feelings or their opinions, and nothing more than that. At the end of the day, the government will want to put to the House their 13-1B motion, and all they'll want to do is get that passed.
Mm-hmm. So that would be really the only vote that ultimately counts?
Well, I don't want to say yes to that, because I think if there was a majority for some other propositions expressed before you got to it, and I'm calling it the principal motion because that is the vital one, it's the one that has some statutory effect, it opens up the gate to ratification, that if some of the other motions were passed, that would have considerable political force.
But they wouldn't have legal force?
They would have no legal force.
Okay, thank you, that's really helpful.
The House of Commons Library argues that if the House were to vote in favour of an initial motion, that the original words stand part of the question in the procedure that the government is proposing, then amendments which insert in or add words to the end of the original motion could still be moved. Now, is that correct procedurally?
Chair, I never like to open with the phrase the House of Commons Library argues. It doesn't argue, it just says things. So I'll argue.
Oh, sorry. Right. It's never argumentative, is that?
I hope not. No, it's
fine.
Always,
all right.
And it's always right. It's like saying the Holy Father argues. Look, if you believe that the ministers were proposing to transpose literally the Standing Order 33 procedure about Standing Order 30, the one about opposition days.
Yeah.
Now that only bites under certain circumstances. A, the amendment has to be moved by a minister of the Crown, which is, I think, quite unlikely in these circumstances. In fact, inconceivable. If you're having a literal transposition of those procedures. Secondly, it has to leave out all the effective words and insert other words, which is quite likely that some of the amendments that are conceived won't do that. They may be additive, to use the phrase additive rather than suppressive and additive or substitutive. So they may be any number of a class of amendments. But the standing order, the precise standing order, only bites in those circumstances. And it has to be all the effective words. So, I mean, in practical terms, it's not likely that if ministers do pursue that course of action, they will literally read across from the standing order on opposition days. They will create a special procedure that enables them to move the motion, effectively move the motion first. If it's defeated, then we'll go to amendments. I mean, they're not going to say it has to be moved by a minister or that it has to leave out all the effective words and add other words. So in that sense, that is quite true. And even on an opposition day, in theory, where you did have and if the government amendment were defeated, you could theoretically move on to other amendments that were merely additive. In practice, the Speaker selects one amendment on opposition days if one is moved. So that is with respect, and as I say, it's a rather theological point, because that's not how anyone would conceivably operate it.
Okay, thank you very much. Jacob Rees-Mogg.
Chairman, can I just continue on the first resolution at the moment? Because if the government puts down no business of the House motion and just follows the usual proceedings, and the debate completes all its time available, only the one amendment would be taken, and that would be taken first before the motion. Is that right?
Broadly, yes, with the disadvantage it would last for 90 minutes.
Yes. And so if the government puts down a business of the House motion, that is amendable in any way, theoretically. Business of the House motions are generally amendable, aren't they?
Oh, they're amendable.
Yes.
It's the phrase in any way that I'm being cautious about
Yeah.
saying yes to. No, they're not amendable in any way, but in any way within the reasonable, what the Speaker judges to be a reasonable footprint of the motion.
So if the only business of the House motion were to extend the time from 90 minutes to 6 hours, it might be unlikely that the Speaker would consider amendments that, or can you not go that far?
I really don't want to speculate on what the Speaker might select, but it's a very fair question.
What would the normal practice have been?
The normal practice is to look at any amendment tabled and decide, in the interest of the House, what should and shouldn't be selected.
Mm-hmm. So the government almost has to put down business of the House motion purely on the 90-minute time frame.
Effectively, I mean, they've not concealed that they're going to, so yes, we can say they don't want a 90-minute debate. And they've also indicated that they have an idea as to the sort of way they'd like to organise the vote. They'd also, I suspect, and I don't want to stray too far, but I think they've also would be under pressure to allow for more than one amendment to be taken if they did allow for amendments. And that does also require a business of the House motion, as you know, that otherwise the Speaker can only select an amendment that we then debate. The question is then proposed on the amendment, at the end it's put, and unless he's given the power, he doesn't have power to move on to then put in sequence other amendments.
And is that true even if a closure motion is put before the end of the available time?
Well, it doesn't matter when the closure motion is put, but once the moment of interruption is reached or passed, he can't start going through processes of other amendments on the paper.
And the issue, I think, I just want to clarify the answer to Ms. Reynolds on the freestanding resolutions. And your view, as I understood it, that the 13.1b motion has legal effect and would therefore be justiciable in the courts and is not an exempt proceeding in Parliament. But
Sorry, what do you mean by not an exempt?
Well, it's normally the courts cannot examine proceedings in Parliament.
Well, can I stop you there?
Yes, please.
I think it's, again, without being hypothetical, and the courts shouldn't examine proceedings in Parliament, but they're perfectly at liberty to take notice of what Parliament has decided. I mean, they do so all the time when they look at an act of Parliament, which is the two houses and the monarch, obviously. So they're perfectly at liberty, particularly as I understand it, and I'm not a lawyer, if both parties agree, to say the votes and proceedings for X January shows beyond doubt that this is the resolution the House came to. Now, if the government rely on that resolution as being meeting the conditions of 13.1b so that they can ratify the withdrawal agreement, and someone wishes to say, but it doesn't meet the conditions of 13.1b, I can't conceive that we would want to stop the courts saying there's no doubt what Parliament agreed, and we're not discussing how they agreed it or how they voted or their own peculiar internal workings, but the fact of the motion is there, and that's sufficient for them to be able to deal with it.
So 13.1b, a specific 13.1b motion can go to the courts to determine whether the government is allowed to ratify or not. But
yes.
Can the courts consider around that any of the other freestanding resolutions, or as they're not referred to in statute, would they, in the normal course of events, be protected by parliamentary privilege?
Again, that is to some extent, a legal question, and I'd rather not speculate. If you read, and I'm sure you will have read, the Miller judgment, the Supreme Court did and does use sometimes as material to help it assist coming to a conclusion other material, including sometimes the views expressed by Parliament by resolution. And we have an ongoing dialogue with the judiciary where that is appropriate and sometimes where we think it hasn't been appropriate. For example, the courts are properly cautious about using the conclusions of select committees as if they were fact.
Mm-hmm. Well, that's the disappointment.
Yes, or indeed the evidence, or indeed the evidence given to them. So, for example, I would hope they wouldn't look at my evidence this morning. It's not sworn. It's not evidence in a court sense. It's my testimony to you. So there are areas of caution where courts should tread and do tread with great care. But if they're trying to find something out, they're entitled to look at records, so long as they don't dabble in the proceedings, which means how we got there.
So is there, to some extent, a hierarchy of parliamentary motions? That is to say, an Act of Parliament at the top of the tree, a motion provided for by an Act lower down, but very important, and then other motions passed by Parliament which may be used to help interpretively but cannot change the law. Is that a fair summary?
I think
of the
that's a reasonable summary.
position?
I would add orders of the House of Commons, which I hope the courts won't generally concern themselves with, but in the past they did, when we used to order, as you will remember, the streets to be kept open, which I'm...
Great pity we don't still do that.
That was a cue for you to say that.
Thank you.
Thank you. So I think the courts could pay attention to that when they were dealing with a case, a motoring offence, for example, which we had about 100 years ago, when a member who made an illegal right turn into Hyde Park claimed as a defence that the road should have been held open for him in order to be able to do that. And the magistrate did pay passing attention to it before fining him.
Thank you. Could I move on very briefly to the motion in neutral terms? Do you think the motion, if an amendment were accepted, would then be the motion provided for by the Act?
The Act says that, as you will know, but just for the clarity of this, a Minister of the Crown must make arrangements for a motion in neutral terms to the effect the House of Commons has considered the matter of the statement mentioned in whichever the subsection is to be moved in that House by a Minister of the Crown within 7 sitting days. That's all that has to happen. He or she has to move it. The Act has no interest in what happens thereafter at all. So they've done their duty under statute if they have ensured that such a motion has been moved, which in their best judgment is in neutral terms to the effect that it's considered the matter.
So even if our favourite procedural motion that the question be not now put were moved, and therefore the motion were never taken, the requirements of the Act would have been fulfilled.
As long as it's moved.
Because it would have been moved.
Yes.
Even if never voted on and therefore not entered in.
Or adjourned, you wouldn't have to try to test the patience of the chair by the previous question. You could just move to adjourn debate. Or lots of things could happen. The Act, I'm glad to say the statute doesn't go that far into our proceedings as insisting that what the House should actually agree or pass.
Okay, thank you.
Now, Vera Hobhouse, I think you wanted to come in on this specific question.
Well, and forgive me if I haven't quite understood everything because the acoustics are not great.
I'm so sorry.
Or also the question, or if I haven't quite understood the contents because it's complex. But I have got possibly a very simple question. If the motion, the no-deal motion was unamendable, what other procedures could the House use to express its opinion, including, even that is controversial, to stay in the European Union? So is there actually any procedure at this point now for staying in the European Union?
Well, I won't take the last question. There's no House procedure that can overcome statute. So you've passed the European Union Withdrawal Act.
Okay.
And you can't overturn that by a resolution of either House, or even both Houses. It would have statute is overturned by statute because we're a law-based society. But the possibilities for expressing opinion in this place are not endless, but quite numerous. And the written ministerial statement made at the time when the current text of what is now Section 13 was agreed pointed out that there are always opportunities for debates in the House. Particularly the opposition have a number of days each year, or each session, I should say, in which they can bring forward motions, which are motions of opinion. And, of course, there's the Backbench Business Committee where backbenchers can ask them to have time on the floor of the House. So that was referred to in that written ministerial statement, which I understood was produced partly to assist the House in deciding whether or not to accept this compromise form of words in what is now Section 13. But if the House passed a resolution that said we're going to stay in the European Union, would we stay in the European Union? No, not as a result of that resolution. Any more than the House has passed a resolution by, I think, 280-something to 0 that we should recognise Palestine as a state. Well, we haven't.
If he passes a resolution that we leave the European Union with no deal, that would be statute?
No. No. These resolutions, in the event of these famous motions in neutral terms, in the event of 21st of January being reached with no deal having been agreed, the motions themselves have no statutory effect. As I was trying to explain, the statutory issue is simply the minister has to ensure there is a motion tabled and a debate. What happens to it doesn't really matter.
Thank you.
Okay, Jacob, you wanted to come back on this point, and then I will
briefly
come to John Whittingdale.
What role, if any, humble addresses could have within this? For example, if a humble address were presented to require the government to ask for an extension of Article 50, or if a humble address were put forward to ask the government to introduce the necessary statutory instrument to change the withdrawal date?
Humble addresses can only be orderly and therefore only be moved if they seek something within the House's accepted powers to be able to do, and that does not include directing ministers to do anything or not to do anything. So, I'm afraid that the phrase "starting with a humble address" isn't a sort of Harry Potter spell by which you can suddenly, the House's powers are extended by merely adding a few words at the beginning. So you can get papers with a humble address, if those, as this committee knows very well, if those papers exist. But what you can't do is order the government to do stuff.
Okay. What about the 19th century post office issue?
Well, I can happily produce a note on the 19th century post office issue, which, as I recall, was about Sunday deliveries. My memory is that in those days the post office was not a statutory organisation, but was it was a prerogative organisation. And there had already been resolutions which they wished to overturn because they changed that the House had unusually changed its mind on the subject of Sunday deliveries. But it is candidly, it's of antiquarian interest.
So the humble address can be used on the prerogative, but not to direct ministers?
Well, it is notionally the prerogative because the Queen, I hope I got this right, between the humble addresses is slightly different if it's a department headed by the Secretary of State as opposed to one not headed by the Secretary of State. She directs the ministers to produce the papers.
Yes.
But she can't, by standard constitutional law, she can't direct ministers as to whether or not to seek an extension of Article 50.
Thank you very much.
Right, John Whittingdale.
Thank you. I think you've sort of covered already the answers to all my questions. But
I'm so sorry.
No, it's very helpful. But to clarify in my own mind, I just wanted to come back and sort of put it in more simple terms. The discussion about the use of opposition day procedures is helpful in that we have now become familiar in the last couple of years with government not opposing opposition day motions and allowing them to pass, but then paying absolutely no attention to them whatsoever. And as I understand it, you're saying that is the government is perfectly capable of doing that on any of these votes other than the gate-opening initial vote under Section 13.
If you're asking, I want to be careful. Are you asking me, is it conceivable that if, for example, we followed the Grieve-Letwin proposition and had a series of resolutions that the majority party, well, of which you're a part, decided to sit on its hands and simply not bother to vote? Is that conceivable? I think your judgment on that is probably as good as mine, but it's perfectly orderly. No member is obliged to vote. There's a standing order that says that.
Indeed, but there is no compulsion on the government to pay any attention to any of those votes.
That is correct. There's no statutory obligation. Right. So let us say there was a majority in favour of a different sort of future trading arrangement to that envisaged in the future framework. Let us say, indeed, there was a majority for a number of different trading arrangements in different resolutions, because when the only precedents close to this are the House of Lords votes in 2003 and 2007, when the business of the House motion explicitly allowed for mutually contradictory resolutions to be passed. So that we voted, I can't remember, but we voted for both, I think, 80-20 and probably 50-50. I mean, there were majorities for things which were just simply contradictory. It was a way, you will remember it, I can't remember.
Yeah, I think the House, the second time in 2007, the House voted both in favour of 100% elected and 80% elected. 80%. In the previous occasion, in 2003, everything got voted down.
Yeah.
So,
as I recall.
But this was a way of testing the House's view, and it was never pretended to be more than that. So therefore the House may come out in favour, I don't know, of Canada plus, of Norway minus, and all sorts of things. Does the government then have to go and renegotiate? No. It then tries to get its principal motion through with whatever it is proposing to the House.
The initial vote which allows the government to proceed with the introduction of the withdrawal agreement and implementation bill...
Can I stop you?
Yes.
I think there's a slight misconception. I'm looking at Speaker's count. If I'm wrong, he'll tell me. 13.1b says that one of the conditions, conditions precedent for ratifying is this motion being agreed. It's not a motion precedent for bringing in a bill. They're quite separate. It says 1D says an act must have been passed. It doesn't say you've got to get first the motion and then the act. So if the motion, maybe politically inconceivable, but the bill is not founded upon the motion. It's not like a finance bill, which requires the motions to be passed before the bill can be brought in. It is technically conceivable that you move straight to the bill. So I don't know if this is shocking, but as I read it, that's quite straightforward. Now, if you can't get the motion, are you going to get the bill? Yeah. Well, second reading of the bill might be seen as, or third reading of the bill, might be seen as a similar vote in type to the motion they need under 1B. So you just said, sorry, they have to get the motion before they get the bill, and I think that is a misconception.
Okay, that's helpful. And when we come to the bill, going back to Vera Hopphaus's question, presumably the one way in which the House of Commons could possibly even vote to stay in the European Union would be to table an amendment to the bill to overturn the European Withdrawal Act.
I really don't want to speculate what would be orderly amendments or new clauses to the bill for many good reasons. And I'm sorry, I'm not being unhelpful. I really cannot. It's a matter, if we get to the bill, it'll be a matter of huge controversy. No one has seen the bill, at least I haven't seen the bill, and the Speaker has certainly not seen the bill, or the Chairman of Ways and Means if we're talking about Committee of the Whole House. And I don't know what would be in the scope of the bill and what wouldn't.
Okay, but that brings me back to where I started, which is that in terms of votes on the floor of the House of Commons, none of them are binding on the government until you get to statute, and then anything that is passed as an amendment to statute is binding on the government. Is that correct?
Yes, that must be correct. If there's a statute that says, and obviously it has to get through the House of Lords, but yes, that is right. That is the way, effectively, that public law is. That's sort of obvious, but that is the way that public law is passed in this country, not by resolutions, as in the French Revolutionary Convention or whatever. No.
Right, I've got a number of colleagues who want to come in, stimulated by the testimony.
I'm sorry.
No, this is exactly what we were looking for. Christopher Chope is next.
When we were discussing Section 13.1 and the resolution, would it be possible for the withdrawal agreement and the political declaration to be separated? Because they are in separate parts. And so would it be possible for the government to bring forward two separate resolutions so that those could be potentially amended separately, rather, because otherwise wouldn't the statute have said that, put it all in one clause, in one subsection?
In one motion?
In one motion, yes. So there should just be one motion, but what they're saying, there should be two motions. There could be two motions.
So if I may say, your question got more confused towards the end. Look, I understand what you're asking.
Yes.
You read 13.1b, and you're saying, could it be two motions?
Yes.
And my answer to that has to be, that is a matter, and I'm sorry, of the interpretation of statute. If the government puts down two motions, I'm sure that wouldn't be disorderly. It would then be for lawyers to say, does that meet the terms of 13.1b, where it says that A and B have been approved by a resolution? Now, does that mean A has been approved by a resolution and B has been approved by a resolution, or does it mean that A and B have been approved in a single resolution? And that is a matter of interpretation of statute. The answer to me is sort of obvious in common sense, but I'd rather not share it with you, because it may be wrong in law.
Okay.
So, because this is statute and not a standing order, I'm not going to try and interpret it.
Okay, I understand that.
Thank you.
So when we have the debate, if there is a debate on Section 13.1, and there may or may not be amendments put down which may or may not be votable on before or after the main question, all those amendments which are regarded as being in order will be able to be debated in the course of the several days for this debate, won't they? So that
it is inconceivable to me you wouldn't have a general debate on if it is in this form, a principal motion and all selected amendments. That is now the common way the House runs. So it's not a question of what gets debated, if I may say. You're absolutely right. It's a question of what and how and when it gets decided and to what effect.
So there could then be this general debate, and during the course of that debate, people will be expressing their views on various possible amendments. Mm-hmm. And without the need for the specific resolutions on any of those or specific amendments being put, the information coming from that debate could then be used by the government when it draws up its withdrawal legislation.
I hope the government, there would be a debate,
yes,
and no doubt ministers will listen keenly to what colleagues say, and indeed if there's something comes up in the debate they hadn't anticipated that they wish to in some way reflect in a bill, I guess they could do it. I'm not sure whether it doesn't matter where it's leading, sorry. Sure, there will be a debate, presumably a long debate, on all these matters. Yes.
When every possibility will be able to be raised by members.
I can't see the chair stopping a member in such a big debate on the basis that they are outside the scope of it. I suppose there are some things that would be outside the scope of debate, but nothing that we're talking about. No, there would be, I assume, a wide debate.
Yes.
Yeah.
My final question is the linkage between the future relationship and the withdrawal agreement. Is it going to be possible to make sure that the two are linked in law together so that one is dependent upon the other?
There's, I think, two questions there. If the government wanted to do it, could they draft a bill that made, in some way, some aspect of it, or aspect of the future relationship linked in some way to withdrawal agreement? I imagine yes, but I'm not the expert on that. If you're asking the government having introduced a bill that didn't have such a linkage, which I suspect you are,
yes,
would it be possible by way of new clause or amendment
yes,
to try to link it? Again, I come back to, I'm afraid the answer I'm giving, that's about what sort of amendments or new clauses might be open to selection when the bill comes.
Thank you.
Okay. Now I've got Jonathan Ginogly next.
Can I just confirm that what I think you said, which is that effectively the government can ignore its main resolution on the deal being lost and move on to the withdrawal bill in any event?
I wouldn't say ignore. I hope I didn't.
No.
I think technically it could. It could move to the bill, and if it thought it had a majority for the bill, it could import, I imagine, and this is pure speculation, it could import into the bill a retrospective provision saying that the passage of the Act, that's to say the bill that will become the Act, that the passage of the Act shall be taken as meeting the necessary conditions set out in 13.1b.
Yeah, because it seems to me that the amendments, particularly if they were taken, if they were going to be taken earlier, in effect become a sign of what people would prefer in an ideal world, whether or not they're going to vote on the government's amendment or not. Because I, for instance, might prefer the Norway deal, but I might have told my whips that I will vote for the government's deal as well. So in effect, what I'm saying is, if for any reason, government, your bill fails, then I would like to see the House move towards the Norway option.
Yes, and avoiding not avoiding the specifics, whether it's by way of amendment to a principal motion or precedent resolution before a principal motion, if there is an amendment or a resolution that says Norway is a good option or the preferred option, there may indeed be, and this is politics, so I'm being careful, there may indeed be members who want to express that view, but also might, when it comes to it, on the binary question, support the resolution. I assume that is the politics of it, but you know
yes, indeed,
much better than I.
Thank you.
Right, Seema Malhotra.
I just wanted to come back, and thank you very much, David, for coming in today. I just want to come back because I'm not sure I now understand the term in neutral terms.
Could you say that? I'm so sorry, I'm not hearing you.
I'm not sure I fully understood what you were saying about the term in neutral terms. I just want to come back again to what using the words in neutral terms has actually done to change the effect of the outcome of any motion in neutral terms.
Well, and I'll try and be as open as possible about how I think we got to this, because I don't think it's a secret. I think the framers of these provisions about obliging ministers to lay motions in neutral terms to the effect that the House of Commons has considered a matter was intended to engage the terms of Standing Order number 24B, which is not a secret, which says that if, where in the opinion of the Speaker or the Chair, a motion that this House has considered the matter is expressed in neutral terms, no amendments to it may be tabled. So what the framers have tried to do is to lay upon ministers the duty to lay a motion that in the Speaker will be more than likely to regard as falling also within the terms of Standing Order 24B, and therefore no amendments may be tabled to it. That, I think, was the purpose behind that phraseology. So if it succeeds and the minister lays such a motion and the Speaker looks at it and he is not obliged to go along with this, he will look at it and say, does this motion, I'm now seeing, fall within the terms of Standing Order 24B? And if he says yes, then no amendments to it may be tabled. So it was as close, I suspect, as in statute the framers could get to saying, well, it's supposed to be an unamendable motion. My proposition was simply that although this may matter politically, it may not hugely, it doesn't matter statutorily, because having laid the motion and ensure that it's been moved, statute then loses interest. So that even if you had an amendment, it wouldn't have statutory effect. So if it hadn't had all this motion in neutral terms, even a motion purporting to instruct the government to go back to the negotiating table in January wouldn't actually force the government back to the negotiating table, other than if the House passed it. You might think, how could a government survive without doing what the House wanted it to do? Is that...
Yes, I think that is better.
We'll go round in circles on this, and that is clear. That it's just the chain of something then having legal effect is what I'm not fully clear.
Well, the motion that the House has considered the matter, if the House passes it, has no legal effect. It's a House proceeding.
Yes, that's right.
If the motion is defeated that the House has considered the matter, that has no legal effect. In the event that the Speaker decides that whatever the Secretary of State's advice that he's tried to meet the terms of the Act and laid a motion in neutral terms, for some reason the Speaker doesn't agree and allows amendments, and there's an amendment to the motion and it's passed and the motion is amended as passed, that has no statutory effect. These are merely House proceedings which we control, or which you control. So none of them have any statutory effect. There's simply a duty to have a motion moved in the terms of the Act in the event of the defeat of the principal motion, or subsequently a no deal being either visibly a no deal being reached, or the Prime Minister telling us that no deal has been reached.
So just to be clear on this, no, you're being very helpful, but I'm just trying to understand the position that the Speaker has been put in by Section 1(6), because the statute says the motion must be in neutral terms, and that then engages 24B of the Standing Orders of the House, which also refers to a motion in neutral terms, which, if that's what the Speaker considers it to be, there can be no amendments. I think what we're trying to get clear is what discretion might the Speaker have?
Complete.
So
The
in other
Speaker
words, the
decides. He is not... he's obviously bound by statute, but he's bound by standing order. He doesn't have to lay the motion.
No.
A Minister of the Crown has to do that and has to try to obey the law. And I'm sure that they will take legal advice as to how to table such a motion, which is in neutral terms to the effect that the House has considered the matter of the statement. And the Speaker's not going to argue with that. But when he sees the motion, he will look at it, and then he will look at Standing Order 24B, and that is for him to interpret with what advice he seeks.
But say the motion was expressed in the terms you've just put it.
I haven't. I'm sorry. I haven't said how the motion is going to be expressed.
No, but if the motion was that the House has considered the government statement, that
yes.
sounds pretty neutral to me.
Does it? Right.
Well, it does, but anyway.
But the question
I'm just trying
is
to be
not
clear
whether
whether the Speaker would have... You said he's got absolute discretion, but if that's pretty neutral, does he actually have any discretion?
Yes, he interprets the standing
okay,
order.
Helpful.
It doesn't matter, with respect, what it looks like to you.
Indeed.
It doesn't matter possibly, hugely, what it looks like to me. It matters what it looks like to him.
Fine.
And the House has to put the trust in the Speaker to interpret the standing orders.
That is very reassuring. Thank you very much. Now, do you want to come in on this particular point, then I'll come to Pat McFadden. Vera Hobhouse?
Basically, what I understand is that any motion has no legal effect. So in order to express meaningfully anything, it would need to the House would need to pass a different law, a new law.
If you're talking about some resolutions of the House have legal impact, for example, 13(1)(b), you're being asked to vote yes or no, and it has legal effect because if you vote yes, it opens one of the gates to eventual ratification of the withdrawal agreement. So that has legal effect because the statute says it has legal effect. When you agree an affirmative instrument, that has legal effect. The affirmative instrument comes into play, stuff happens. When you agree to an early general election, as you did last year, I don't know if you did, the House did.
No, I wasn't.
To an early general election in 2017, that has very considerable statutory effect all around the country. So I'm not saying resolutions have no statutory effect, but they only have statutory effect if the statute has been passed that gives them effect. The House has powers over itself and over its own proceedings, so I can be told to do things by the House, as can you. But it can't order public law. Public law is passed by public law.
Okay.
I'm not a lawyer, and you're talking to lawyers later. So
we are indeed, imminently. Finally, I think Pat McFadden.
I want to take you back to this question of what we might call the Grieve-Letwin proposition of these freestanding motions. You've said to us this morning, if I've understood you correctly, that the only motion that really counts is the government motion because that stems from section 13(1)(b), and the others, to go back to Mr. Rees-Mogg's kind of hierarchy, don't count as much in layman's terms. Is that a reasonable interpretation of what you said?
I don't think that's quite what I said, that they don't count. This is a political environment. I mean, obviously you know that, but I think anyone else listening or reading should know that.
What's a better phrase for not counting?
They don't have statutory effect.
Okay.
Yeah.
So if the House were to agree that there should be a referendum before X or after X, that would have no statutory effect. No referendum follows as a result.
Right.
But if there's a majority of members of the House of Commons have voted for it, I think you'd be very unwise to say that had no effect.
Okay.
I mean, it would have, I assume, a considerable political effect.
Okay. Let me then pursue that kind of example if it was done another way. Instead of this freestanding smorgasbord, as Mr. Letman put it, we had such a proposition passed as an amendment to the government's main motion arising from section 13(1)b, either in the way that the Secretary of State has set out, with the main motion being taken first, then voted down in favour of such an amendment, or...
Sorry, no, I've got to stop you there.
Right.
When you said voted down in favour of such an amendment, that's not how the House works. If you're voting on it first, you're voting yes or no.
Yes.
If you're voting yes, there would have to be a special procedure to subsequently allow amendments to a motion when the motion itself had been passed. And then it'd be up to the government will bring forward a business of the House proposition. But you're not then you don't know what the results of any one of a number of amendments may be. So once the government's lost the main motion,
yeah.
And again, I'm moving into politics. I mean, if the government wants to go first, and the House agrees to the business of the House motion, which it has to do before any of this happens, if the government goes first and it says, the House, would you please agree the negotiated withdrawal agreement and the framework for the future relationship, and the House says no, I'm not quite sure how much there's continuing political significance in what there is a majority for, but you might find the government have to some extent lost interest because they've lost. They have lost the main battle, and this is then... do you see what I mean?
Yes, I do. Right. But what I'm trying to get at is the sort of hierarchy of these House decisions. Let me put it another way. Let's say the House decides these things in the way that normal business is decided, where amendments are voted on before we get to the principal resolution. And an amendment, such as, to use the example you used, that says, this House agrees this package subject to a further referendum. What is the legal effect of that?
That is the expensive question, meaning I am not a lawyer. And that is the big statutory question. Now, the government's memorandum, which you will have read to the Procedure Committee, expresses their concern that if the resolution is spoiled, which I think is my shorthand and others are using it, by anything other than the pure milk of agreeing to what it says in 13(1)b, that it casts doubt as to whether or not that gate has opened for them to be able eventually to ratify. So they think it casts doubt on it. Now, it's sort of obviously cast doubt on it if you have a future conditional amendment which they are not able to meet. But that is a question for their lawyers. If such an amendment were passed, and then, incidentally, the motion as amended were agreed, it would then be for lawyers to determine whether or not 13(1)b's condition had been met. It's not a procedural question.
But is there a difference in the weight attached to such an amendment relative to the same text being passed in a standalone motion of the kind that Dominic Grieve and Oliver Letman put to the Procedure Committee?
Well, there is only political weight attachable to either. Obviously, the difference between in the Grieve-Letwin proposition, the resolution doesn't spoil what I would call the principal question, which is coming along at the end. The yes-no, the binary question on the 13(1)b resolution. So if you have standalone resolutions, that is obviously designed as a means of avoiding any risk of, as it were, either deliberately or possibly unintentionally spoiling the principal resolution. So that's the difference.
Why is an amendment to the principal resolution regarded as spoiling when this is what Parliament does?
Well, when I say spoiling...
week in and week out.
Sorry, perhaps you either misunderstood me or you're being mischievous.
No,
when I use the word spoiling, it's a perfectly entitled thing to do, but that the government is saying they will then have legal doubts in the case of some amendments, and absolute certainty in the case of others, that they have not got the 13(1)b resolution they seek, and you're perfectly entitled to do that. I say spoiling, meaning from their point of view they have a resolution and they wish to have a yes-no, and if you have a chance to amend it, you're perfectly entitled to, but it has spoilt it from the purpose of does it any longer have statutory effect? And that, if you read their memorandum, show you that they are expressing concerns, legal concerns, as to the effect. So perhaps spoiling is a bad word, but it's vitiating its effect.
With the Chair's indulgence, if I could ask you one more thing. If the binary resolution, as you call it, is passed, what's the impact if the withdrawal bill, which gives effect to it, is either not passed or is itself amended in a material way?
Well, the resolution under 13.1b is just a statutory gateway that has to be opened. At some point, or dealt with, before they can ratify. But having been passed, if it is passed, it's sort of dead, isn't it? I mean, we then move on to the next stage, which is the bill. And if in the bill the House either changes its mind or is able to find a different centre of gravity around some proposition, we don't go backwards and revisit the gate we've opened to get into that field, because we're now in that field and we're moving forward to the next gateway, which is getting the Act. So if you see what I mean, you don't have to go backwards and repass a resolution or something. That would be pointless. But it is for them a necessary precondition in statute for them to be able to ratify the withdrawal agreement.
But there are other gateways in the bill, other options.
There are other
options in the bill in the sense that it can be amended.
Oh, absolutely. We've discussed that. I mean, the bill is... I wouldn't say the bill is the thing. I mean, the bill will be, I assume, the next. As I've said, it doesn't. The bill is the next thing, and it will be open to amendment. Although, as we've discussed, I can't speculate to have what breadth or depth of amendment, because we never do. But yes, of course, we're open to amendment.
Thank you.
Just, John wants to come in finally on another point, but just to pursue this a little bit further. We heard earlier that even if the government's clean motion, not a term I like, is defeated, the government can bring in the withdrawal bill, in part to try and correct that problem and say, well, actually, Parliament's decided it's okay. Therefore, if the amendment the hypothetical amendment we've been discussing, approves the withdrawal agreement and the future partnership...
Could you say that, I'm sorry, if the hypothetical amendment...
If the hypothetical amendment, which is the House approves the government's withdrawal agreement and the future partnership, subject to a referendum, there would be nothing to stop the government then bringing in the withdrawal agreement and implementation bill, presumably, and it could put that on the statute book saying, well, that means that when we have a referendum, we're ready to go if it gets approval. The thing it couldn't do, am I correct in thinking, is actually to ratify the agreement under the CRAG procedure. So it could do the bill, but it couldn't ratify under CRAG because the House would have said ratification is subject to the outcome of a referendum.
I think I'd rather leave CRAG aside because it's a further, possibly minor complexity, which I suspect the government may find other ways to deal with if they have a majority, rather than opening themselves up to yet further pre-ratification tests. But you're saying, could they proceed to the bill? Yes. And if they can get the Act through, which contains provision for the implementation of the withdrawal agreement, then what are they going to do about their uncertainty? If there is uncertainty, if there is legal uncertainty, and this is again a legal issue, there is said to be legal uncertainty about the 13.1b motion as to whether or not it has actually been achieved. And they would, as I've suggested and others have suggested, they would quite conceivably wrap that up in the bill. Is that...
Right, but it would be a political question as to whether the government paid any attention to the House's requirement that there should be a referendum, for instance.
It would be a political decision, just so, but obviously they might be faced, if it were possible, with a similar proposition, if it were selectable, in the bill.
Yeah, okay.
If it turns out there's a majority in the House for that, it's unlikely that there won't be at least an attempt made to do the same on the bill.
Indeed. Very helpful. John.
One last question, because I was asked this by somebody in the city yesterday, for whom it is hugely important, apparently. What is the fastest that the government could get this bill onto the statute book? Can they get it on by Christmas if they initiate the procedure, say, at the beginning of December?
Well, whether in the city or anywhere else, I'm sure lots of people like to know that. Well, look, the fastest that a bill can go through, we've got Acts of Parliament introduced as bills in one house, passed by both houses, and got royal assent within, from memory, under 24 hours. But that's where you have a consensus that we proceed in this way, and also we have another chamber. So if the House has a majority to get a programme motion, or possibly an allocation of time motion through the House on this bill, then they can. I have to be, they can do it as fast as they can get away with, if speed is the essence. They don't have the same freedom in the House of Lords.
That's a whole other matter. Now, Stephen's caught my eye.
Of the withdrawal agreement, could that happen before the withdrawal agreement implementation bill becomes an act?
No. The 13.1d says the withdrawal agreement may be ratified only if an Act of Parliament has been passed which contains provision for the implementation of the withdrawal agreement.
So it has to be. Thank you. Sir David, we are very grateful. That's been a terrific session. We haven't been too taxing.
I haven't been too helpful. I think I may have been.
Well, thank you very much. Right, we are going to move on to our second session. The microphones remain live, colleagues, just remember. That's great.
Yeah, I mean, if you had the bill, you could effectively amend.
Second session. I'm very grateful to all of you for coming today and for your patience. We've got, as you will have heard from the previous session, a lot of ground to cover and questions to ask. Can I welcome Dr. Jack Simpson-Caird, Senior Research Fellow at the Bingham Centre, Dr. Sarah Hageman, Associate Professor in European Politics at the London School of Economics and Political Science, Raphael Hogarth, Associate, Institute for Government, and Dr. Simon Usherwood, Reader in Politics, University of Surrey. Now, if I could begin and just ask each of you, because we've got a lot of ground, succinct possible answers would be really helpful. I might start with you, Mr. Simpson-Caird. The government has prayed in aid in the memorandum that the Secretary of State sent to the Procedure Committee its deep concern that there might be legal cases brought if their clean, in inverted commas, motion is not passed in an unsullied form. It'd be very helpful to us if you could set out what kind of amendments might engage that fear, that there was a reasonable case that could be argued in the court that the terms of Section 13 hadn't been met, and what kind of amendments would not. In other words, would have a lower or nothing is a nil risk. But I think you get the point. So it'd be helpful to us to understand, and since I'm looking at you and you're looking at me, Mr. Simpson-Caird, I'm going to ask you to...
A nice easy one to begin with. Well, I think that the main test with any amendment made to the motion is, does it change the fact of approval or not? So the statutory test is that the motion must approve both the withdrawal agreement and the future relationship. So any amendment made to the motion which indicates in substance that there is disapproval to either agreement, that wouldn't pass the test. That's the clearest possible example.
Yeah.
Then I think you enter into a grey area when you start talking about any conditions that you attach, because then the question is, could the condition prevent the withdrawal agreement or the future framework being agreed? If a condition was added for an amendment that would potentially stop them being agreed, then that doesn't amount to approval. If it's a potential block to approval, like a referendum, then to my mind, then that wouldn't be approval. I think the clearest category of amendments that would allow the motion to still amount to approval would be things that would happen after exit day. So if there was an amendment to say the agreements are approved subject to the House of Commons approving the government's negotiating objectives on the future relationship after exit day, then that, in a sense, doesn't change the fact of the Commons approving both the agreements. So that would be my sort of way I would make a distinction.
Just can I follow that up? Approval subject to a referendum, since that's been a theme of discussion. But I don't quite understand why that is fatal, because in effect Parliament would be saying, yeah, it's fine by us, but we just want to check with the people who started this whole process off and see whether it's fine by them. It's conditional approval subject to a bit of process, a rather important bit of process in those circumstances. But I don't see why someone would be able to go to court and say, challenge that in some way. I struggle, but I'm not a lawyer.
Well, I think approval means it approves, not approves subject to something which could result in it not being approved. I think that's the problem. If it's a potential roadblock to the withdrawal agreement needs to take effect on the 29th of March 2019. If the thing that you're inserting into the motion could result in that not happening, then I think that's...
But then to pursue that point, the withdrawal agreement and implementation bill might not be passed. So why is not somebody arguing that having a withdrawal agreement and implementation bill is not a potential roadblock to approval, because if it doesn't get through, then you can't actually go on to ratify, because you're not going to be able to implement the thing anyway. So I don't see what the difference is between the bill, say, and a referendum in this hypothetical case.
I think it's a different question in relation to the bill. The question is, what does the words of the statute, section 13(1)b, says that the House must pass a resolution which approves. And so the question is, what does approves mean in that context? And I think approves means approves. And it could include adding words that don't interfere with approval. But if the words could interfere with approval, then I think that would raise doubts as to whether or not it's approved.
That's really helpful. Now,
Mr. Heldoff, could I say a couple of words about that?
Of course.
Suppose we get an amendment of the kind that you described, saying we approve conditional on a referendum. There are two ways that could then go. One is the government says, we're ignoring that, we don't want to have a referendum, we're going to proceed and ratify anyway. Because, as far as we're concerned, that doesn't have legal effect. It's still a motion to approve. In that eventuality, I think your litigation risk is probably high for the reasons that Jack suggests. Or the other way it could go is that people could say, well, Parliament has amended to require a referendum, we need to have a referendum. And then I think the legal question probably fades from view. And the reason for that is that the only reason the legal question would arise is if we were still talking about ratification of the withdrawal agreement under Section 13. Somebody wanted to bring a challenge in the courts over the interpretation of Section 13. But, there's going to be loads more legislation if there's a referendum. There's going to be legislation to set the terms of the referendum, for one, in which Parliament can clear this business up. It can say in that legislation the government may ratify if X, Y and Z, notwithstanding the provisions of the European Union Withdrawal Act. And so I think probably in that scenario we wouldn't need to be too worried about the legal questions surrounding Section 13, provided that Parliament was pretty clear in its subsequent legislation.
Okay. Let's take another example. Parliament says we are happy to approve the agreement, subject to the government giving a commitment that in the waiver bill they will legislate to ensure that Parliament has a vote on the terms of any treaty or treaties that comes out of the future partnership negotiations. Now, would that constitute approval or not?
That's a difficult legal question on which the House would probably want to seek legal advice, and the Attorney General would probably be sent to give the government's legal opinion to the House on whether that would hold up the ratification of the agreement. I think potentially a more natural place for that kind of move by parliamentarians might just be amendments to the withdrawal bill anyway. Yeah. Because there you're probably not so worried. You're probably not going to be as worried that it's going to sully the Section 13 effect in that event.
Ms Hageman or Mr Ashford, anything you want to add on this point? No? Can I just ask, any of you aware that this concern about potential legal challenge was raised during the course of the consideration of the withdrawal agreement bill? Does it spring to mind?
I don't remember it.
You don't.
I've not read through Hansard.
No, well, I'm not expecting to remember every word, but I mean, no, that's fine. Very helpful indeed, John Whittingdale.
No.
You're fine. Okay.
For the moment, I wanted to come a bit later.
Later. Fine. Pat McFadden.
Thank you, and good morning. Could I begin with you, Mr Simpson Caird, and ask you your view on this debate which is taking place between whether the right way to do this is, I'm going to use the word normal, which in a subjective way, is the normal way that Parliament would do these things, which is to consider amendments to a main resolution first and vote on them, and only if they fall you then proceed to a vote on the main resolution, or the way that the government has suggested to the procedure committee, which is more like how opposition day business is conducted, where the main resolution is considered first and any alternative proposition is only considered if the main resolution falls. What's your view of these two ways of doing this?
Well, I think the principal advantage with amendments first is that you get the House to make a series of decisions on a series of propositions, and I think that's what some people assumed the meaningful vote would involve, and that it wouldn't just be a straight yes or no decision. It would involve a sort of negotiation, if you like, between the Commons and the government on a series of different options. And I think if you have the amendments first, and that's perhaps more likely to happen, that negotiation, than if you have the amendments afterwards, where you raise the stakes of that first vote on, because you can only get to the amendments if the government's motion is rejected. And I think that the sort of things that we were talking about, potential amendments that could be compatible with approval, you're less likely, if you're in favour of approval, to risk voting down the government's motion first, because you don't know what might happen afterwards. You don't know that there might not be a majority for any of the amendments moved after the original government's motion is rejected. So I think it's a more risky procedure, perhaps, to have the amendments afterwards, from the point of view of someone who may or may not want there to be amendments considered and decisions been taken by the House on those amendments.
The view's been put that by taking the main motion first, it is more risky, because the only way any MP can get to talk about anything else or any alteration in that is by voting it down.
It's not about talking about it. My assumption would be that the amendments they would be debated, and then all the division would take place.
Okay, deciding rather than talking about. In other words, the view's been put that the government's proposition actually maximises opposition to the main motion, because the only way a member can vote on anything else is by voting that first proposition down. Do you think that's a risk the government is running?
I think that's a political question to an extent, but I can see your general point that you would have a coalition of people who want different amendments, potentially, people from different perspectives, saying, well, we want a chance to give our view on these particular amendments, so we're going to have to take this decision first. And also there's the point that rejection of the government's motion first doesn't necessarily mean that you wouldn't get approval resulting in the end, because the amendments considered after the original motion is rejected could, in theory, have approval, but in different form of words. So it could the alternative amendments considered after the main motion could say the House approves the withdrawal agreement and the future framework subject to something else. So you could still get approval, perhaps, if, in that circumstance.
Going back to the session that we just had with Mr. Natzler, where we talked about the motion and the bill, do you think there's a danger that politicians have been focused too much on the resolution and not enough on the bill, given that the bill itself can be amended in any number of ways?
Yeah, I think that's a very good point. I think constitutionally, from a domestic point of view, the legislation is much more significant because the legislation is what grants transition, it's what grants citizens' rights, it's what... we know from the withdrawal agreement text that's already been agreed, there's some constitutionally significant content in that agreement that's going to have to be translated into domestic legislation, and obviously potentially the protocol on Ireland and things of that nature. So I think, as you say, the political attention is on the vote because that precedes the legislation, but in constitutional terms, the legislation is arguably more significant.
Thank you. If anyone else would like to come in on this, first on this question of, if you like, amendments first or amendments later?
I would just say one thing about that, which is just about the sort of rationale for the opposition day procedure, which is that obviously in the context of opposition motions, hearing your main motion first and then going to amendment is sort of the best way to hear the variety of opinions in the House, simply because most of the time the government's got a majority. Right? So if you let the government do its amendment first, then it's just going to supplant the opposition day motion. You're never going to hear the opposition day motion. The opposition isn't going to have a chance to put its case. Whereas obviously here, that logic doesn't necessarily apply. So the sort of parliamentary, the rationale behind the opposition day procedure in terms of parliamentary principles isn't necessarily applicable to this case. I think the only...
Because you'd never get to the amendments, potentially.
Because you may not.
Yeah.
And so you wouldn't be giving minorities in the House, or indeed potentially majorities in the House, the opportunity to air their views. But at the same time, obviously, that procedure does lower your legal risk, and that's a political question, whether you're more concerned about reducing your legal risk or hearing what the House has to say. On that question about the withdrawal agreement bill,
yeah.
I think that's incredibly important, and I completely agree with Jack that that's going to be a bill of serious constitutional significance that requires careful scrutiny by the House. The other thing that I'd say about it is that I worry a bit that it's going to be a bit of a political nightmare, partly because I'm not sure everybody has fully digested yet how politically unpalatable some bits of that bill are going to be when they turn up. Things like essentially keeping the European Communities Act in force for a while, giving ministers powers to make payments to the EU. And partly because, obviously, when you're considering the motion, you're looking at the whole package. So the government can say, well, I know you don't like this bit, but there's all this other stuff that you do like, including an orderly transition and a really ambitious future framework and the rest of it, so can you please just vote it through? That's much more difficult when you come to considering the withdrawal agreement bill, because you might just be voting that the bit on the protocol on Ireland stands part.
Yeah.
And we've potentially got very serious problems if the government can get the motion through but can't get the bill through, because the bill is what gives effect to the agreement in UK law, and is also a condition precedent of ratification.
I think it's a very important point. Imagine one focus in the mind of the government workers. I don't know.
It's maybe just underlining that last point, that as far as the EU is concerned, the last decision that it has had from the UK was notification on the 29th of March 2017. And so the default outcome is a no-deal exit for the UK. So the bill is essential as part of that ratification process. And if there is questions of amendments or changes, that will be the way that would be communicated back through to the EU. So in terms of the European level of this process, that will be the much more consequential part. That a motion is not going to be having any material impact on that process of Article 50.
But an amendment to the bill might.
Potentially, depending on what the amendment to the bill is.
Okay, thank you.
Okay, thank you. Peter Grunt.
Thank you. Can I follow up on that point you just made to Dr. Usherwood? Sometime during 2015-16, Parliament was completely in charge. We had the option as to whether to approve the referendum bill, whether to amend it and whatnot. We're now in a situation where you've described it as the default position. If something else doesn't happen, we have a no-deal Brexit on 29th of March, which few, if any, members of Parliament have said they think is a good idea. At what point, since the autumn of 2015, did we pass almost the point of no return, where we moved from Parliament having the power to decide what happened to Parliament trying to find a way to stop it from happening? Was it when we agreed to the Article 50 bill? Was it when we agreed to the withdrawal bill? Was there some sort of point where Parliament effectively stopped having the chance to be in full control of the Brexit process?
As far as the EU would see it, the point at which that changed was the 29th of March 2017, when the UK submitted its letter of notification under Article 52. So Article 51 says a state can choose under its domestic procedures to withdraw, and then it notifies, and that will start that 2-year window, at the end of which, unless there is a deal, that member state will leave with no deal. So that is the point at which decisions were made which have a material impact on this.
Thank you. Can I move on to a very specific question for sort of any or all of the panel who want to answer it? When we come to the EU withdrawal agreement bill, what does that need to say about the protocol on Ireland and Northern Ireland? Does it need to say anything? Does it need to explicitly give approval to it? Or can it ignore it completely and hope that it will be fixed at some other point? I've never managed to stump an expert.
I think from the European side of the debate and the negotiations, they've been very clear that they require a backstop that is in operation, and that we're now kind of getting into what amendments there might be, that the withdrawal agreement, including that the protocols, would need to be approved in the form that has been signed prior to the moving of motions and bills here in the UK for ratification purposes. So if Parliament decided that it was doing something different with that, it would depend rather what that different thing was and whether there was any indication from the EU about whether it considered that acceptable or not. Because we have to remember that as well as UK ratification, there will also be ratification by the European Parliament and the sign-off from the Council, which will come after the UK has done its part, largely for that reason, that the UK, if the UK doesn't like this deal or doesn't want to leave on those terms, that is largely the UK's, it is the UK's prerogative. So the EU has negotiated in good faith, as has the UK. If that deal is not acceptable to Parliament, then it will depend how it's not acceptable.
Thank you.
If I can come in on this, a question was made earlier about how here domestically there would be a linkage, a close connection between the withdrawal agreement and the bill and any future arrangements. And I'd just like to point out that the sequence on the EU side is quite important to keep in mind in this respect, because the approval process, as Simon just mentioned, with requiring the majority in the European Council and the consent of the European Parliament, at this point in time it's very clear with the points that have been made about the EU's demands for withdrawal agreement would be fairly straightforward if those conditions were met. So the backstop is an absolute red line in that respect. But any future relations to be negotiated subsequently the European Parliament has a different role. It has to adopt it differently to just giving its consent. And so the European Parliament and the approval process on the EU side is perhaps fairly quick if we are to think that the withdrawal agreement would be what has been made clear from the EU side, and if the UK were to agree to that at the end. But it is unknown as to what the dynamics would be for future relations going forward.
Thank you.
On the question of the protocol, I think the key question will be what the actual text of the protocol actually says. So if you look at other examples in the draft withdrawal agreement, there are things that clearly do require domestic legislation. For example, in relation to citizens' rights, there's a clear statement that the UK courts must be able to disapply incompatible legislation that's incompatible with relevant citizens' rights. So if the text of the protocol makes clear that there must be domestic legislative effect, then in order for the UK to ratify, one is presuming that the relevant legislation must correspond to whatever the withdrawal agreement says it must do. I think one important point to make there is that so that you can assess the legislative effect of the withdrawal agreement, arguably there's a case that the government should publish the withdrawal agreement legislation at the same time as the withdrawal agreement so that they can be read alongside, so that you can appreciate the domestic legislative implications of approving the withdrawal agreement, precisely because of the danger that you approve one and then only establish the legislative consequences when the legislation is presented.
Thank you.
And I would
sorry.
Very quickly say, I think you probably have to do the protocol in the withdrawal agreement bill. If you think about it from an EU perspective, the whole point of the backstop is that it's an all-weather insurance policy. So if you imagine a scenario in which the UK has undertaken that as an obligation in international law, but hasn't actually got the implementing legislation through Parliament to make it happen, or to make it happen if it needs to happen, then from an EU perspective, people are probably going to be thinking, well, what if there isn't a majority for this in Parliament at the time we need it? All you're relying on at that point is UK parliamentarians' belief that the UK is a good international citizen that upholds its obligations in international law, whether we like those obligations or not. Now, it may be the case that the EU is generously prepared to take that view of the UK at the moment. My instinct would be that it probably isn't. And if it isn't, then I expect it's going to want to see provisions for the protocol and the withdrawal agreement bill.
Could I just get clarification on that?
That it would certainly be tactically, politically helpful as a way of persuading the Europeans to agree to it. Is there any legal or constitutional requirement within the domestic setup of the United Kingdom for it to be included within the withdrawal bill?
I don't think there is.
Okay.
Can I just pursue this point? Because are you saying that, given where we are, that the European Parliament, because we'll have the approval of the deal here if it goes through, we will have had it approved at some point in this process by QMV in the Council, and then the European Parliament has to approve it. Are you saying the European Parliament might say, right, show us you put this all into legislation before we're going to give the go-ahead? Are you saying that is a possibility?
Hypothetically, it could be a possibility, but at the same time, it is. I would think it unlikely, but right. It is a possibility. So the consent that the European Parliament has to give is a simple majority.
Yeah.
The British MEPs have a vote on it, the European Parliament has had the right to complete access to information throughout this process, and they have been kept informed. They are very involved, and they give their views, especially on the issue of the citizens' rights.
Yeah.
They have also voiced their strong opinion and support for the Irish backstop issue. So I think that it is the European Parliament should be seen of the very same opinion as the governments in the European Council, but of course either of those two institutions could ask for that sort of evidence, but they would. I would not expect the European Parliament to take a different position than the Council.
From the Council.
Yeah.
Because it's a bit like David Cameron's renegotiated deal. There were people in the European Parliament who weren't terribly happy, but I think the view from the Council was, look, we've agreed it, for crying out loud, agree it too.
No, but also the European Parliament has had a chance and continues to have a chance to give its opinion and input to the negotiations.
Absolutely.
And they have been heard, and they have certainly played a role throughout this process. So it's not that they are being given a take it or leave it vote at the end of the process. They have highlighted, especially with regards to citizens' rights, their strong opinions on these matters as well.
Well, it's been very clear in all the conversations we've had, for example, with Guy Verhofstadt as a committee.
Right.
Stephen Timms.
Thank you, Chair. I want to ask you about the discussions around the future framework. We've been kept quite reasonably informed about what's happening with the withdrawal agreement. We've seen draft text, we've been told it's 80% complete and 95% complete and so on. But we've heard nothing at all about progress on the discussions around the future framework. Why do you think that is?
Well, everything depends on a withdrawal agreement and what kind of relationship the UK is proposing and willing to get into itself. And so from the rest of the EU, there has, from the very beginning, been a whole range of options available, from the Norway model to the Canada model or others. And I think that at this point in time, there is still many options available, but the conditions of any of these arrangements are also very clear, and with the UK government's position that it is to leave the single market and that it is to leave a customs union. Of course, we are going in a direction which looks less and less like a Norway model. But of course, you know, the politics, they change from day to day at the moment, so it could be that this would come back on the table. I'd just like to say, though, that the priority being the withdrawal agreement and the conditions that lays out, it is unlikely that a Norway model or something of that kind can be a temporary solution, simply because that comes with the same sort of conditions as EU membership regarding the four freedoms, etc. So unless the UK was to accept those, we cannot imagine that it would be a Norwegian model. But also these other alternative options, they take time to negotiate. They have implications for the existing members. Norway, Liechtenstein and Switzerland will have to of course, accept a UK membership. And also their concern on this point in time that it doesn't open up questions about their relationship with the EU. So this is just to say that whatever outcome the existing EU members are hoping that the UK will be as close to membership as possible on the conditions that are very clear for EEA membership, etc. But these things take time to negotiate, and it is not easily conceivable that can happen from this point in time until a withdrawal agreement came into effect.
Okay, can I ask you any of you, what sort of document do you think the political declaration about the future framework is going to be? Do you think it's going to be a lengthy, detailed document? Do you think it's going to be rather a short?
I'd expect it to be shortish, a 15-pager. I've heard that number floating around. Who knows? Could be more or could be less. And with very positive mood music and not a lot of detail. And I think that's ultimately the answer to your question about why we haven't heard very much about it. It's because it's the bit that you can fudge, because it's not legally binding text. It's a political declaration, and so in a sense there's less pressure on it.
Is that the expectation of all of you, that we're talking about a perhaps 15-page document, quite a short document?
I don't have any comments on how long it might be, but I do think that for the meaningful vote, the framework on the future relationship is the most difficult element of the process, because it's an unprecedented thing to ask Parliament to do, to approve a political statement, something without legal weight, which is the foundations for a negotiation which hasn't yet taken place, which is only going to take place after we've left the EU. And I think when we're thinking about what procedure, how the meaningful vote should work, I think one of the biggest challenges is that the idea that there will be this document that we're a bit unfamiliar with as a document, and B, we're not quite sure how we should adjust the procedure in order to deal with what will approval of this document actually mean. I think is a very difficult parliamentary question.
If what we're going to be presented with, potentially in the next month or so, is a 15-page document, is it your understanding that there is a draft of such a document somewhere between here and Brussels? Or? You don't know. Mr. Verhofstadt suggested to us that that this document could be given legal force by making it an annex to the withdrawal agreement, and the committee commended that idea to the government. Do you think there is merit in that idea, or?
I think there would be a lot of caution on the EU side regarding this, because we need to keep in mind what repercussions this could have for other EU member states. It will be in the EU's interest to get a good agreement with the UK and to keep the relationship strong, but at the same time, current governments are also under pressure domestically from various sides regarding their own membership. Now, EU membership on the continent has become much more popular, and even the very sceptical EU countries that have often looked to the UK, they continue to watch what's going on here with the negotiations. So it is not to suggest that the UK is being treated in any punitive way, but certainly there is an interest from the EU side to stay united and to give a deal to the UK that is not favourable over membership itself. And that is an important point, because the negotiations as they are right now, they are also in a political climate in Europe which is very difficult for the sitting governments. So I also believe that it would be from the European side in their interest to keep it short and without much detail regarding a future relationship, but that it is clear that it is not something akin to EU membership itself.
Right. And can I just a final point, Jack? We know the political declaration in itself it won't be legally binding, but can I just ask Jack? You've made the point, I think, that it will have legal implications. Can you just tell us something about what those might be?
So, yeah, I think what I meant was that there would be indirect legal implications, because already Parliament has enacted Brexit legislation with delegated powers that are designed to deal with multiple outcomes, so namely the EU Withdrawal Act 2018, the correcting power, which is Section 8, I believe, of that Act. Now, we know that power will be used to get rid of some EU legislation that we don't need. And when it was originally introduced, it was designed to prepare for exit date March 2019, but the latest white paper on implementing the withdrawal agreement said that it will actually also be used to prepare for the second exit day, the end of transition, at the end of December 2020. So what I sort of meant when I made that statement was I thought that if the future framework says certain things, rules certain things in, or rules certain things out, like freedom of movement, for example, then that could affect the sort of legislative preparations that occur between now and the end of transition, even before we get to the treaty on the future relationship. So I was trying to make a point sort of analogous to the debate we had about implementing the withdrawal agreement when we had the European withdrawal bill before the House. There's a question of, will we start implementing the withdrawal agreement before we get the final version of the withdrawal agreement? I think there's an analogous point to be made. Will we start implementing the future relationship before we get the finalised version of the treaty? And obviously that will depend on how much detail and how much certainty there is with the framework.
And I wonder whether, Sarah and Simon, whether you can say anything about the legal implications from the EU side arising from the political declaration.
Yeah, again, I think the EU's concern will be one of uncertainty about where the process is heading, the uncertainty about where the UK's settled position will be and whether that will be clear at the point of signing a political declaration, and also in that period of negotiation following withdrawal next March. We also have to remember there's going to be uncertainty on the EU's part that it is also going through continual changes of government on national electoral cycles. The European Parliament election will produce a new Parliament and new Commission during next year, which will produce a necessary hiatus in those negotiations anyway, that whilst the mandate nominally will continue through that period on negotiations, it would be, I think, evident that member states would want to revisit that once withdrawal has taken place and once they know what the Parliament and the composition of the Commission look like. So managing that uncertainty will lead to a degree of caution about how to approach this. And just thinking about the future relationship, we talk about a treaty. It may well be that there are a number of treaties, that you might have a framework document that provides the basic parameters, and then subsequent series of parallel negotiations on specific areas of policy which come in at different points. So the process is likely to be complex and coloured strongly by political preferences on both sides of the table, which are going to change. And we know that member states do have more varied preferences around what the future relationship might look like than they have in relation to the withdrawal process under Article 50, where the strength of unity behind the Commission and its programme has been very strong. You're not going to see quite the same level of coherence of political preferences on that future relationship, all of which points towards uncertainty and a degree of unwillingness to get pinned down on things that might cause more trouble later on, given already the considerable amount of difficulty that is associated with it.
Just on the legal effect of the future framework, if I may, two things I'd say. First of all, this idea of having it as an annex to the withdrawal agreement, which I haven't heard before, I think probably more important than the structure of the document is just looking at whether it contains clear, enforceable rights and obligations. So if it's an annex to the withdrawal agreement, which says things like the UK and the EU recall their commitment to enter into a highly ambitious free trade agreement, that doesn't sound to me like a binding enforceable obligation. If it says specific things that either or both parties will do and explains the consequences if those parties do not do those things and the sanctions that are available if they don't do those things, then it's starting to look like a legally binding document. But I don't think that's the direction in which we're heading. The other thing on legal effect is if you wanted to give it a little bit of legal bite, but not necessarily the kind that I just described, then you could maybe have a legal obligation to negotiate on the basis of it, which you put in the main withdrawal agreement, but obviously a legal obligation to negotiate isn't the same thing as a legal obligation to conclude an agreement.
Okay, now...
So one thing about linkage on that point. I think there is a danger that with the idea that the withdrawal agreement contains some kind of binding provision in relation to the framework, that creates more confusion than is desirable, because at the moment we know that we have a withdrawal agreement which is legally binding and we have a political declaration that isn't. Anything which muddies those waters and you have different lawyers saying different things about whether or not the declaration is binding, I think is a bad thing.
Okay, now Vera Hophouse wanted to come in on this point.
Just on Guy Verhofstadt, because he came here and said things quite clearly to us, but and you've been saying the European Parliament has got a degree of, or quite a lot of power in the say. So he said the framework doesn't have to be detailed, but it has to be specific. So he was very clear about it, whereas you've just said it probably won't be specific. So how do we square that circle? I mean, it's all speculation, but of what's been said to us here about 4 months ago, he said very clearly it had to be specific.
Well, I think it could be both specific and, in some respects, non-specific, in that it could say, we anticipate that we'll negotiate towards outcome X, be it a free trade agreement or Norway or whatever. But in the same way that the Council guidelines in the past have said, if the UK's red lines change, the EU will revisit its offer, you might expect the same kinds of provisions in the future framework, basically to ensure that the negotiation is able to reflect political changes on either side.
You can be very specific about the areas that you might want to cover without being specific about what this final agreement comes out as. I think it's worth underlining that for the EU's negotiators, they will be bound by the other treaty provisions on relations with third parties under 207, 217. That this is an Article 50 document because it's associated with the withdrawal agreement, but that can't be a basis for long-term standing relations with third countries, which has to be done on a different legal basis, which would involve a different approval mechanism by the European Parliament, member states, all of those things. So you can have a detailed intention, but you can't have a detailed obligation on the EU through that path, because that would infringe the EU's own legal basis for concluding that agreement.
Okay, now I've got a couple of others on this specific point. Emma Reynolds.
Very briefly on this, given that the political declaration isn't legally binding, even if it did include specific things in it, there's nothing stopping a new European Commission and a new European Parliament, which could look very different politically to what we have now, and indeed a new government here, from throwing this thing up in the air and starting again, or having something entirely different. Is that the case?
That would be my understanding of it. We also have to remember that after the 29th of March, after withdrawal, the UK is no longer a member state, so the situation changes, and so we're in a discrete part of the process. So statements made in the political declaration are statements made, but whether they are obligations on how to act and how to pursue negotiations subsequently, I think necessarily is constrained by the situation, as you say, that any of the parties can change what they might wish to achieve and wish to do. That I don't see any party being willing or able to tie its hands with an obligation to reach an agreement, either on the specifics of the political declaration or even in general to reach a conclusion. So it's a bit like the clerk earlier talking about the motion, that you can make the statement, but then you can't actually oblige everyone to follow that in the manner of international negotiations in general.
I mean, I completely agree with that. I think the only caveat I would add is obviously you have the shadows of both the backstop and of the transition looming over the future framework, and there may be legally binding provisions within the withdrawal agreement about the circumstances in which the backstop would come into effect and/or the transition would cease to be in effect, and obviously that those are things with a great degree of relevance to your future relationship. So I think it wouldn't be true to say that there will be nothing in the withdrawal agreement that will create any legally binding obligations with respect to the UK's future relationship with the EU. But it would be true to say that the political declaration on the future relationship itself wouldn't contain such obligations.
One of the things I think from a domestic constitutional perspective be looking for in the political declaration is how on earth you're going to get it done in time by the end of December 2020. And so I think one of the things we'll be looking at is what will Parliament's role be in the transition in terms of delivering that treaty, because it's such a tight timeline. When will the treaty be presented, and all those sort of questions. And I think that's one of the main things.
Okay, now I've got Christopher Chope on this.
David Davis was the Secretary responsible for this. He envisaged that essentially we'd have these two documents side by side, and that we'd have the withdrawal agreement ratified by the 29th of March, and early in April we'd have more or less the document that would be setting out the future relationship, which would be more or less completed, but it would then be subject to ratification under those EU rules. That vision has in a sense been complemented by the repeated assurances we've had from the Prime Minister that nothing's agreed until everything's agreed. So in the light of what you've been saying, how is the Prime Minister's assurance to the people going to be delivered if there is no legal nexus, binding legal nexus, between the withdrawal agreement and the declaration of the future arrangements?
Well, I think that's why the UK government wants the legal linkage, in order to make that precise point. So the legal linkage is what the whole thing will hinge upon, is that to say that, you know, because we've got this legally binding commitment in the withdrawal agreement that the content of the framework will be delivered, then that's how you explain that position. Right?
I mean, there are two ways of interpreting the phrase "nothing is agreed until everything is agreed," right? It might be nothing in the withdrawal agreement is agreed until everything in the political declaration is agreed. That could perfectly well be true. Or it might be nothing in the withdrawal agreement is agreed until everything in the future relationship itself is agreed. That's not true.
Okay. Right, John Whittingdale is next.
I want to sort of explore that a little bit, and also to come back to something Mr. Hogarth said earlier in the session, which was to talk about the unpalatability of certain measures within the bill. Particularly, I think you suggested around the flexibility to allow ministers to make payments. And I wondered if you could say a bit more about that. And when it comes to the linkage and the difficulty of establishing linkage, the Secretary of State had previously suggested to us some time ago that the bill could include some conditionality on payments to link to outcomes. But given the difficulty of specifying outcomes, and indeed the possibility that the declaration could actually be torn up completely by a new commission or Parliament, how practical do you think it is to try to include amendments to the bill which would make future payments in the financial settlement somehow conditional on an outcome of being achieved?
The short answer is I don't know. The slightly longer answer is there are sort of two things that you've got to think about. So the first thing is what we do in the withdrawal agreement bill taking us sufficiently far away from the obligations that we've agreed in the withdrawal agreement that the EU is going to say, hang on a minute, I'm not sure we're happy to conclude this deal with you by March 2019 after all. And the second question is what we do in the withdrawal agreement bill taking it sufficiently far away from the treaty that even if we do agree the treaty by March 2019, it could subsequently be found that the UK is in breach of its international obligations under that treaty. And I think that this also goes to the question that the chairman was asking earlier about what the repercussions might be of, in some way, getting it wrong in the bill, for instance, by not including Ireland. And I think I don't know the extent to which the EU at negotiating level is going to be looking at what you're doing in the withdrawal agreement bill, whether we're trying to make payments conditional or anything like that. But inevitably, in terms of enforcing that agreement, subsequent to its signature and ratification, whether the UK has legislated to give effect to those obligations is going to be a material question, the material question. And I think that one would want evidence from the EU side and also potentially from lawyers about whether that kind of conditionality being introduced in the withdrawal agreement bill would render the UK in breach of its international obligations.
So you're suggesting Parliament could impose a conditionality?
Well, Parliament is sovereign. Parliament can do whatever it likes.
But the EU might come back and say, hold on, that's not what we agreed. This is not the deal, and therefore we won't proceed on the basis if that conditionality is included.
Yeah, I mean, I think there could conceivably be domestic arguments about whether the bill, if sufficiently amended, still satisfies the Section 13 requirement. I think it probably would, but again, that's a legal issue on which you'd have to get an opinion from a lawyer, but I think basically the analysis that you just presented is right.
And can you just go back to the question about unpalatability?
Well, the withdrawal agreement bill is going to do a few things. It's going to provide for transition, it's going to provide for citizens' rights, it's going to provide for the financial settlement, provide for other separation provisions, and potentially, although the white paper doesn't make this clear, provide for the protocol. Now, in all of those, I think there are going to be some quite politically difficult provisions. Jack mentioned earlier on the provision in Article 4 of the draft withdrawal agreement that basically saying that the UK will ensure that in future, if any Parliament legislates against the citizens' rights provisions, that new legislation will be disapplied. That's essentially trying to preserve the supremacy of EU law with respect to citizens' rights, and the EU also, in some respects, wants to preserve the supremacy of EU law with respect to other things. I think that could be politically difficult. The power to make payments, as I mentioned, could be politically difficult. Keeping the European Communities Act in force until the end of transition, or saving for its effect, I think is the government's phrase, which would essentially mean putting on hold the first clause of the European Union Withdrawal Act, I think could also be politically difficult. And so I'm anticipating some potentially quite challenging days for the government in Parliament as it's getting this bill through, which, as I say, is a worry, given that it's a condition precedent of ratification.
I think you're probably sensible to state that.
Okay.
Can I just pursue this point of unpalatability, as we're now describing it? The Northern Ireland only backstop. Now, we know this is the outstanding issue for the conclusion of a withdrawal agreement. We read that there appear to have been some discussions about whether something could be put in the withdrawal agreement about a commitment to negotiate another arrangement along the lines that the United Kingdom government prefers. But presumably the government could say to the EU, yeah, we didn't legislate for the Northern Ireland backstop in the Wabe bill, because A, we don't think it's ever going to be used, and B, if it ever did come to be used, that's yonks away, because it's at least 21 months, and it could be longer if we have to extend the transition period. So it can't be for you, O EU, to tell us by what date we have to legislate for the different commitments that we've entered into in the withdrawal agreement. Wouldn't that be a reasonable argument to make? Ooh. I'm judging the facial expressions, but you'll need to turn those into words.
Well, I'd defer to the EU colleagues on how the EU would react.
Yeah. I think that would not be seen as acceptable on the EU side. I think that the backstop question is something that has sort of been given prominence lately, but it's been criteria from the EU side all along. It's not a new issue. And the commitment to ensure that the backstop is in the withdrawal agreement from the European side will not be seen as sufficient, that it is a matter of domestic legislative process to delay such an agreement.
I think it's worth adding that the EU has had enough concerns about the status of the backstop up until now that it will not want to go down a promissory route, that the agreement on the joint reports, at the publication of the draft withdrawal agreements, statements from ministers and others in the UK about whether this was actually as binding as the text suggested it was, I think has made both the EU and certain member states, notably Ireland itself, very concerned to make sure that it has a watertight legal basis, that it is a genuine all-weather backstop. So whilst there are always going to be issues about how things change in the future, that will always be a concern. So again, the issue was already mentioned that yes, you can make a promise that you will put it into effect at the relevant time, but that will be dependent on local political conditions over which you can't be sure. So if you're
but
determined
except the government might put the Northern Ireland backstop in the legislation today, and another government might take it out of our legislation tomorrow. So it comes back to Mr. Hogarth's point, which is you enter into an international treaty, you're regarded as someone who does what they promise internationally, and the expectation is that you will at the appropriate time. And the point I'm trying to explore is whether the EU can actually say, well, it's not in your version, we're looking at your current version and your amendments to the EU withdrawal and implementation bill, and it's not in there, and if it's not in there, then all bets are off. Because similarly, does that mean the British government could say to the 27 member states, well, we're looking at your legislation and we don't yet see provision for clarifying how British citizens are going to get their rights permanently under the citizens bit of the agreement? I mean, this you could end into quite some difficulty if we're checking each other's method of implementing what are clear international agreements that we're signing up to.
I mean, parties are always checking each other's.
Yeah.
I mean, that's what the European Commission does to us now. It checks whether we are complying with our obligations under EU law, as indeed to private parties and citizens before our own courts. So I think in any event, it would be perfectly legitimate for either side to raise the kinds of concerns you're discussing.
And then the dispute resolution body
exactly
decide.
Once we've got an agreement and you say, I want to enforce this agreement, you're not complying with your obligations under the agreement because you've not legislated to do so properly. Like I say, I think it's a much more difficult question whether that could get in the way of agreement before March 2019.
Yeah. That is very helpful. Seema Malhotra.
Yes, thank you very much. Absolutely fascinating evidence session. I was just wanting to pick up on this point about the extent to which there's going to be any real weight coming from the political declaration at this point. I just want to think through a scenario here. So we will leave, assuming we leave in the way that is planned, we'll leave the European Union on the 29th of March next year. Subsequent to that, we will be entering negotiations on the future framework, which the forerunner is the political declaration. That could be one treaty in the end, or it could be a series of treaties. And those treaties could be perhaps independent of each other. So there could be possibly treaties signed through the period of transition if there is agreement reached on different areas. I think we've had some evidence to that effect before. But say we're in a situation where there's a delay with the changes, the European Parliament, Council, Commission. Probably we won't be into active negotiations until this time next year. Then there may be a year with new teams in place. We don't know what the political reality will be over here either. So if there's a scenario in which there aren't any treaties that are signed or agreement that is reached on the future framework, what happens come December 2020, assuming that there isn't an extension of the transition period?
Another cliff edge.
There's not another cliff edge, and then sort of back to where we could be without a deal March 29. So possible default into WTO.
Well, that's
not even that.
But that's not even a given. The thing is that, and from the EU side, this is seen as very regrettable that we are in this situation. First of all, because of the UK being the UK, and then regretting that the UK is leaving in the first place, but also the fact that we are at this point in the negotiations. There's no certainty about the withdrawal agreement, but there's also no certainty about what the UK would want the future relationship to look like. And from the European side, that is seen as adding to that uncertainty in the negotiations over the withdrawal agreement. So they are linked. And the Article 50 text says that the withdrawal agreement are to be completed with a view to the future relationship. It's not giving any specific guidelines as to there needs to be something specific agreed. It's just with a view. So there's a hope that there will be some clarity regarding what that future relationship will look like. But at this point in time, as far as the EU 27 are concerned, we have no idea. And therefore, it is correct the way you say that the timeline will be that the withdrawal agreement has to come through, and only at that point will there be real negotiations over what a future relationship will entail. And that could be any of the options still that have been on the table from the very beginning. But the expectations are that we are nowhere near a Norway model. It is much more like a free trade agreement. That's the expectation at the moment, simply because of the way that the negotiations have unfolded and the red lines that have been made early on from the UK government regarding leaving single market, regarding leaving customs union, jurisdiction of the ECJ, etc. That will take time to whatever agreement has to be negotiated. You're right that even that transition period will be a very, very short period of time to get anything through. Mind you, the ratification for that agreement is also quite different from the withdrawal agreement. In fact, depending on the kind of agreement, if it is an extensive agreement, which would mean that there is an extension of the EU territory with the relations to the UK in some way, ECJ jurisdiction, etc., that would, for some countries, even require parliamentary ratification. So it is important that the withdrawal agreement now preferably has a steer to which direction this goes, and then day one after the withdrawal agreement comes into place, that there is serious negotiations about taking this forward.
Okay. Thank you. Jonathan Ginocchio.
Thank you, Chair. I'm going to drag us back actually towards Peter Grant's question, because could I just confirm that the panel agree with what Sarah Hageman said, that in effect it's very unlikely that the European Parliament are going to vote against a withdrawal agreement? I think you said on the basis that they're looking at it on an ongoing basis, and therefore they're unlikely to. They know what's coming. Was that?
They know what's coming
right.
under the current proposal, and if that is the basis, there's an expectation that the majority in that requirement in the European Parliament would approve it.
Right.
Yeah.
Would everyone else agree with that?
Yes, broadly. Yeah.
Yeah. Great. Okay. So on that basis, if there was a shock and if they did vote against it for whatever reason, what would actually happen?
If you had non-ratification by one of the parties, then the agreement isn't ratified, and if you haven't found an alternative arrangement, then you get to the 29th of March and the UK would leave without a deal. I presume that in the scenario where one party, not just the European Parliament, but any party specified that they weren't happy to approve, they would be suggesting what it would be necessary to make them be in that position. So then there would be a discussion about whether it was a matter of renegotiation or something else.
So an Article 50 extension could come from the EU?
It could.
Request?
Yes. All sides can ask it, but the European Parliament can only ask the EU to consider asking for it, because the European Parliament itself can't ask for an extension.
Yeah.
An extension, by the way, of the Article 50 negotiations require unanimity in the Council, and there would have to be a clear reason for why that transition should be granted, especially as we are looking at European Parliament elections, new Commission, budget negotiations, and what have you.
So quite a tough call, you're saying?
Yes, absolutely.
Okay, thank you. And the other thing I was looking at is that it seems post-Brexit that there's going to be a disparity in the scrutiny provisions that exist between the UK and the EU. In fact, there's a disparity today. Post-leaving, I suppose European scrutiny, European Committee B or whatever it is, I think it's European Standing Committee B will presumably be dissolved. There are promises from Dr. Fox that there's going to be some kind of new regime being brought in to review future trade agreements. But this doesn't really stand up when you look at the processes that exist within the EU. And I'd just be interested to hear the panel's views on whether you think what we have is adequate, or what instead we're going to have will be adequate, and how it compares with the EU. Jack Simpson-Kev.
That's an interesting question. I think the presentation of the framework is an opportunity. It's sort of an invitation for Parliament to think about, well, what is Parliament's role going to be in turning this framework into a treaty? Having had the experience of Article 50 and learnt the lessons of whatever those may be from the Article 50 process, what does Parliament want its role to be in the negotiations on the future relationship, and also at the end of those negotiations, what does it want its role to be in relation to approving that agreement? Does it want to replicate the conditions in Section 13 for the withdrawal agreement for the future relationship? Does it want to guarantee itself a veto at a particular moment in time, perhaps before the European Parliament gets a chance to give its consent to the future relationship? So I think there are, you're right that this is the moment of maximum leverage for the House of Commons to say, well, when we've left, we want to make sure we have at least a similar level of responsibility as the European Parliament has.
Right.
Also, during transition, the UK, under the terms of transition, would still be applying and transposing EU legislation. So where that's a matter of statutory instruments, there'll be a role there for Parliament.
How is that reviewed?
So even though the UK won't have the legislative input into decision-making during that time, there will be certain issues where the UK might be able to advance its opinions about potential legislation. Yeah. So again, Parliament would still have a role and a place in that process.
Sarah Hagan.
Yeah, so EEA members, they have the right to giving early positions equal to EU members on legislation. And I think that there's a lot to take note from how, especially Norway, has their parliamentary setup, because, of course, it's not only about influencing, but also how, in trading with EU and any relations with the EU going forward, legislation here will certainly be affected, most likely. So I think that there are other countries to look to for some sort of best practices, or even in some cases where it's not working so well, but that that there are conclusions to be drawn.
Thank you.
Okay.
Thank you.
Do any of you think that it is realistic that the negotiations on the future partnership will be concluded by December 2020?
I think it depends on two things: what you mean by concluded, and what's in the future relationship. So, if the future relationship is something which is to a great extent off the shelf, and by concluded you mean agreed between negotiators, but not necessarily ratified or implemented domestically, then yes.
But let me then qualify the question. Concluded to the extent that we wouldn't fall off a cliff on the 1st of January 2021?
Well,
because you just said not implemented.
Yeah,
it could be concluded but not implemented. If it's not implemented, then don't we fall off a cliff?
Well, you'd probably have to make some provision not to fall off a cliff. So,
which sounds like an extension.
Well, it might be extension-ish.
Extension-ish. Now that's
which
a
is
new
to
concept, but yeah.
Which is to say, basically, after you've completed your negotiation, you need what is actually an implementation period. Right? What we've got now is not an implementation period. There's nothing to implement. And during your implementation period, you might actually get what the Prime Minister has at some point discussed, which is a phased implementation period, at which different parts of your future relationship are brought forward as and when the domestic structures and the administrative structures, enforcement structures are ready for them. Are we going to, on the 1st of January 2021, have everything ready to go? No.
No.
You can have a provisional. You can have a provisional implementation of a future relationship. So even if you're in the middle or at the start of ratification with all the parties, in the way that you had, for example, with the CETA deal, you can have that provisional application of parts of the agreement. So you can have a partial implementation of the future relationship. And again, if we're talking about the framework document with some subsequent or parallel negotiations on specific areas, you might be able to get that in. It depends very much what it is you want and need to, which cliffs you don't want to fall off.
I'd like to stress also that from the EU side, there is a wish to get moving with things very quickly. The uncertainty that all of this creates, and this has been the case, of course, during these negotiations up until the point of a withdrawal agreement, but certainly the continued uncertainty about what the future arrangement will look like is also something that the EU would like to settle very quickly, especially in areas such as security, of course, in the trading between the different markets. But certainly there is a lot happening on the continent at the moment where the UK has an interest in participating, but also where the EU governments would very much welcome that it becomes clearer what kind of role the UK could play alongside the EU member states.
Okay.
So, yeah.
Now, Mr. Simpson-Coe, Sir David Natzler earlier appeared to suggest that there might be some way the government could get round the CRAG process or find another way of ratifying the withdrawal agreement. Could you think how that would be done?
I don't think you can get. I think you have to comply with CRAG. I don't think he was suggesting that it would somehow. I don't know. Ask the question again. Let me see if I get it.
Well, I seem to recall that he said, and maybe we'd just have to check the record, that the government might have a different approach to securing the final stage of ratification. It was in the context of conditional approval subject to a referendum, and I think I argued, so you could get the legislation on the statute book, but the thing you couldn't do is ratify under CRAG. I think that was a context in which...
Well, you can't ratify under CRAG until you fulfil the conditions, which are to lay the final version of the treaty 21 days before ratification. That's the critical point. And I think the government has said that it doesn't intend that when it lays the treaty for the purpose of Section 13, that's not laying it for the purposes of CRAG. So only after the final version is approved, which may be perhaps after it's been approved by the EU side, then it will be laid, I imagine, under CRAG, and then there'll have to be 21 days before it can be ratified. That's my understanding.
And lastly, on this question of neutral motion, do you think that the way in which Section 13 is framed, in practice, if it is a motion in neutral terms, give the Speaker any discretion?
I think I'd like to stick to Sir David's line on that.
Fine. Well, that's probably a very, very sound and good point on which to end. Can I, on behalf of the whole committee, thank you very much indeed for coming today. It's been a really useful and informative session. Order, order.